The Singaporean court claims zero tolerance for corruption, and the state of Singapore claims zero tolerance for corruption. I have found a case of manipulation of justice and wrongdoing by a judge and a lawyer in Singapore, which I wish to expose. I've tried to keep it internal by sharing it with the Supreme Courts of Singapore, which they are being evasive with and saying they can't see the Dropbox videos. So here it is on YouTube for everybody to see, including the Supreme Court, so they can see this video they said they weren't able to watch. The video begins going through all my email evidence over the past 4 years and begins with showing the wrongdoing of my first appointed lawyer, Mr. Alan A. Johns, who is on the Law Society list and is a completely dishonest and corrupt lawyer. Is complete, overcharging and dishonest. This lawyer was fired by me sometime in November 2015, and 2 months later deleted a case he was not authorized to touch because I was acting in person and against my express wishes, in cahoots with the judge, for no reason, no explanation, without my knowledge and without me filing notice of discontinuance, whilst the case was in my possession, acting in person. And both the judge and Mr. Johns committed a serious offence by doing that without notice of discontinuance signed by me or my knowledge or permission. As you can see on his honours list, which is really just a series of things to make yourself look good, he's a member of the Ethics Committee of the Law Society of Singapore. Well, you're going to see what kind of ethics this lawyer has by the time you finish this video, which I would ask you to have patience and concentration for if you're really interested in corrupt justice and manipulation of justice of the Singaporean justice system, because this video is quite a long one and you need to concentrate to follow and understand the evidence, which is not circumstantial. It proves that a judge and a lawyer illegally deleted a case which I paid $8,000 to file without my notice of discontinuance, without either of them being authorized to do so, and without my knowledge and permission or signature. So after hiring Mr. Alan A. Johns, advocate and solicitors and commissioner for oaths, he told me that the mother had filed a divorce case, which we received and responded to, and it received a date. In the meantime, Mr. Johns himself suggested to me that I file a Guardianship of Infants Act case. And so this is the email sent on the 2nd of July 2015, where Mr. Johns says, or Mr. Alan A. Johns says that he will approach the Singapore Central Authority for assistance. He didn't. If assistance is not given or settlement fails, I will write to your wife to let her know that I act for you and demand liberal interim access. He did write a letter to her lawyers asking for interim access, which was never replied to, and I think he wrote repeated, and it was never replied to. I spent 2.5 years asking both the mother and mother's lawyer and the judges in every case conference and hearing for interim access order, and never received even a peep of a reply. So he says he will file an originating summons under the Guardianship of Infants Act which he did. And he said he would file a summons seeking interim access, which nothing happened, so I assumed he didn't. But apparently, maybe he did. This is to be revealed. If he did file a summons seeking interim access, I know he did send letters to the lawyers, but he definitely did file the originating summons under the Guardianship of Infants Act. And he said an application can be made for the child to relocate back to Thailand, incorporated into the GIA, which is rather difficult, so he was reconsidering that. We made an affidavit after that, and the Guardianship of Infants Act case FC/OSG 139/2015 was filed. To file this, I was first asked for a retainer of $5,000, which later before filing, I was asked for a further $3,000, which I paid both of. And the Guardianship of Infants Act case FC/OSG 139/2015 was filed. And you can see here in the Family Justice Courts of the Republic of Singapore, case number FC/OSG 139/2015, in the matter of Section 5 of the Guardianship of Infants Act, Cap 122, was filed on the 4th of August 2015 at 5:21 p.m. with the hearing date of the 20th of August 2015 at 10 a.m. Hearing type, status conference, child, attend before the registrar. And this was our originating summons to the mother, with Mr. Alan A. Johns acting for me. Yeah. And here you can see where he sent me the affidavit for the Guardianship of Infants Act case on July the 31st. We can see that on the 18th of August, my lawyer Mr. Johns wrote to Mr. Seat, the lawyer of the plaintiff in my case, FC/OSG 139/15, asking for my client's proposal on interim access. Never got an answer, I don't think. We served an originating summons in the GIA, as seen, and on the 5th of August, the plaintiff, the mother's advocates and solicitors sent us a letter about her divorce suit, FC/D 1688/2015, that they want to serve, why they haven't served the divorce papers, because they actually filed the case months or weeks before and never served me or my lawyer the papers. And he lies here talking about obtaining the court's leave to effect personal service of the course papers on my client in Thailand. That's not true. He withdrew the affidavit, which lied, saying they didn't know where I was, and changed the affidavit and refiled it. But this was his letter to my lawyer explaining why he had filed a divorce case but not served me with the papers in time, which he didn't. But at the bottom here we can see, regarding the case we are focusing on, FC/OSG 1399/2015, he says, the mother's lawyer says, "We understand your client has also proceeded to file an originating summons in respect of the child of the marriage, which means my Guardianship of Infants Act case, FC/OSG 139/2015, not 399, 139. And similarly, that they have instructions to accept service of the application cause papers on behalf of the mother, their client, and to kindly arrange to let them have the cause papers as soon as possible. which I suppose they were sent by my lawyer, Mr. Johns. In the meantime, of course, regarding case FC OSG 13915 in the Guardianship of Infants Act case, filed on the 4th of August, this letter was written to the registrar by my lawyer on the 18th of August 2015, that we commenced proceedings on the 4th of August, received an endorsement as the originating summons, scheduled a status conference on the 20th of August 2015, but that the e-litigation system indicates that the said status conference on 20th August has been vacated. My lawyer, Mr. Johns, then asked the registrar that he would be obliged, or that we, me and him, if Your Honour could reschedule a status conference for directions to be given. Thank you in anticipation. Then, and this is something I had not seen, there was a response to Mr. Johns in the Family Justice Courts of Republic of Singapore regarding my case FC/OSG 139/2015, also dated on the 18th of August, written to Mr. Johns, my lawyer. A registrar's notice, hearing date refixed. He informed that the matter was vacated and refixed on the 25th of August 2015. Yeah, and so that there was a hearing given on the 25th of August 2015 for a status conference for case FC/OSG 139/2015, which I do not know what happened, do not know what was said, and Mr. Johns never told me. We go back to the emails now to see what continues after this. And so, in my shock from the abduction and the stress of the case, I actually never noticed this particular document, which was sent to me by Mr. Johns on the 3rd of September. Because I received a different summons which did not have in writing here these two cases. It only had this case written to the invitation to attend the case conference. And obviously Mr. Johns sent me this, but I didn't see it. So my assumption that case conference on the 6th, on the 3rd of September, I attended one in September, and the 3rd of September was to discuss and update on whether OSG, which if you'd have said OSG to me at that time, I did not know that my Guardianship of Infants Act case was FC/OSG 139/2015. I know it now because I've memorized it, but just as a normal person I'd have been completely clueless as to what somebody's referring to if you said, can we remove OSG and tone things down a bit? There's no way I would know. Attending something I received an invitation to which only had D1688 on, and I didn't see OSG 139, and I didn't attend this case conference on the 3rd of the 9th. My lawyer did, and he heard about if at case conference continue at conference whether OSG, which I now know but then did not know, and I never saw this document, can be withdrawn in a new duplicate prayers in the divorce suit, right? Which is what they wanted to do, to unify it into the divorce suit and get me to drop the OSG. This was discussed without my presence, in the presence of my lawyer, on that date. and he sent me this email, which actually, to be honest, I was being a left behind parent in international parental child abduction is also almost sure going to send you into PTSD and panic attacks, and I didn't actually see this email, to be quite honest, at the time. So that's one mistake on my behalf, that in the FCR conference held without my presence, my lawyer was asked to remove the Guardianship of Infants Act case, which he took $10,000 from me to file. No, $8,000 to file and $2,000 to answer to the divorce case. And then straight after, he says, we've been asked to come to mediation, which means, mediate what? Mediate what? And they asked me for a couple of $1,000s more, which I paid. I was then informed that my attendance was required and compulsory on the 6th of October 2015 at 10:30 a.m. And this is the FCR conference I did attend, and I do remember going to, and I think this is the one where I attended with Judge Ming Choi Lim in attendance, ruling over the FDR conference. This was an FDR conference regarding both cases. I was under the understanding that this was regarding a single case. I'm now going to open this PDF to see if I had opened it at the time or just read this and appeared at the court from reading this email or not. And here we are, is what's interesting, and which underlines what I said when we compare the directions from the court following the case conference on the 3rd of September 2015. We can see this here written about the withdrawal of OSG, written in a case conference I did not attend, attended by Mr. Alan Abraham Johns representing me, which names both of these cases. That is where it was discussed, and it was not discussed with me, the client. It was only discussed with my representative, and my representative never discussed or asked me for instructions on whatever was discussed here. Later, as just seen in the iCloud mail, 44515-, number to the 3rd of September 15, PDF, They forward this email. My attendance is required on the 6th of October. So this is the next case conference. After this case conference on the 3rd of the 9th 2015, which discussed without my presence the removal of my $8,000 expensive OSG case to be withdrawn in a new duplicate prayers in the divorce suit, which I was not informed about by Mr. Johns. This should be discussed in the next case conference, both these cases. But the notice to attend received thereafter, on October the 2nd, 2015, that I should attend, notice to attend the next case conference, which, according to this document, is supposed to discuss OSG 139 as is written here. But the notice to attend, if you notice here, does not have OSG 139/15 on it. And this is the notice to attend Family Dispute Resolution FDR conference at the courts regarding case number 0168/2015 only. The other case, my Guardianship of Infants Act case, is not mentioned in this case conference. What was sent to me, this notice to attend. Therefore, lawfully, in this case conference, you should not talk to me about this here, OSG 139, 15. You should not talk to me. This was, without my presence, discussed on the 3rd of September with my lawyer, who never informed me that it was discussed about removing OSG 139/15 in the next conference. Other directions. At case conference. To update at case conference on whether the OSG can be withdrawn in new duplicate prayers in the divorce suit. That's the purpose of the next case conference, 3rd of 9th, 15th. So here we now, 3rd of 9th, 2015, my notice to attend. What is written here? What is written here is, namely, only 0168. Only 0168, 2015. Not OSG 139/15. So I was called to case number this, not to any other case number, on the 3rd of the 9th. And there's nothing here informing me that the previous case conference discussed this, nor that this case is also included in this case conference. Only this case is mentioned. If that's a printing mistake, I don't care. It makes it unlawful. As far as I'm concerned, a printing mistake like that, or not including it, is deceptive and would naturally cause me to have the least assumption, absolutely no idea, that mention or talk about this case here could be discussed during this case conference for case number 01688. And this is the case conference where Judge Ming Choi Lim claims that she asked me to remove OSG 139 and that's not what I heard, that's not what I understood, and I'd love to see a transcript of that. So if you can get a transcript of that, that will contribute to the evidence for or against. And for or against, finding out the truth would be nice. If it turns out that nobody's done anything wrong, that would be nice. It might be embarrassing for me because that would mean that I've made some mistakes, but I've made a couple of mistakes because I was in shock, but I still think there's something wrong here. And firstly, what I'm pointing at here, that there is no mention in this notice to attend of FCG/OSD 139/2015 in the Guardianship of Infants Act case is not mentioned here, for FDR conference. There's only one case mentioned, the divorce, not the Guardianship of Infants Act, on the 6th of the 10th. And so there is no mention here, of that. And that any communications are not to be referred to or used in any subsequent contested hearing. And this is very deceptive, because this notice to attend does not give any inkling that the Guardianship of Infants Act case is also to be discussed here. And so, hello, this is Mr. Spencer Littlewood again, trying to finish this third video, and I apologise for the belatedness because the stress of trying to make these, and because I suffer PTSD, these things bring up the memories, and so I had to take a few days off. I'd like to show you first this email from the 27th of the 11th 2015, where I told Mr. Johns, after the court had told me my GIA case FC/OSG 139/2015 had been deleted sometime in November, from the Family Justice Registrar sent me an email saying that. I then wrote to Mr. Johns saying I'm going to sue him and the judge. I thought I could. I didn't know you can't sue a judge. Anyway, I was angry, so this was just my first short reply in anger to find out that an $8,000 case, which cost me $8,000 to file, had been filed with me completely oblivious to it. And so Mr. Johns replies, read my earlier email, the notice of discontinuance has not yet been filed. The GIA has not been withdrawn. We merely obtained permission to withdraw it. And I sent you a screenshot in the previous email, which was part 2, to show you that he actually sent me a screenshot which showed in December. It was in a later email showing me it was still pending, because I told him the judge had said that it was deleted, or that the FJC had said, the registrar had said that it was deleted. I won't say names because I can't remember who it was who actually sent the email, which officer it was. But if you look through the court email database, I'm sure you'll find every email that was sent to me, and you can look if you're interested to. And if you're not, well, that's to the detriment of the sanctity of your own system. That's not up to me if you want to protect your system or not. I'm just informing you. I personally am solving my own problems, and the case with my joint custody of my son is working itself out slowly but surely through my own hard work, and I don't expect any help from anybody. I don't expect to take action against anybody, and I don't expect to defame anybody. I'm just trying to inform you of things that are going on wrong within your own system, in case you care about it and don't want it to happen. And you can take, what do you call that? Interior affairs. And if you want to deal with it, you deal with it in your own manner. That's up to you and your country. It's none of my business. If you don't care, you leave it and ignore it. And if you do care, you will take action and investigate it. But I'm not asking you to do it for me. I'm asking you, if you care about your country and the sanctity of your justice system, then you should truly have a look into it, and definitely not just try to shut me up or try and charge me with defamation so that I can't come to Singapore and visit my son, who I've had enough problems trying to visit as it is. And so I'm trying to help you. I hope you're not going to try to harm me because I'm trying to help you. Because from what I've read about Singapore on the internet, that's what happens to people who try to reveal things like this, and that's not my intention. My intention is trying to help you. So, Mr. Johns said we merely obtained permission to withdraw it. And so, I will now go to show Mr. Johns when I signed him up. Long before this, about 8 months before, he made a Dropbox account for me. And I sacked him after this in November, after this date here. Just a few days after this, I fired him. And he handed over to act in person. Now, I don't know if it was before or after. You have a copy of my intention to act in person and the email from the FJC recognizing my intent to act in person before the case was deleted. And you will have already the evidence of the screenshot showing that the case was pending whilst I was in control of it. and merely with permission to withdraw it, but I had not filed notice of discontinuance was not filed by me. Yeah, and if it was filed in January 2016, not 2015, and it wasn't filed by me, so who could it be filed by? It can only be filed by the person who is conducting the case, not by Mr. Johns, who wasn't working for me, and definitely not by the judge. It is the owner of the case and the conductor of the case who files the notice of discontinuance. You have no evidence of me filing notice of discontinuance, but you might find evidence of Mr. Johns filing notice of discontinuance sometime in January, 2 months after having been dismissed by me and given express orders to leave the case pending, which it was until that date in January, when somebody deleted it either with or without notice of discontinuance, and definitely without my signature, and definitely without a letter of me empowering Mr. Johns to file the notice of discontinuance. So there is definite evidence of wrongfulness in my opinion, that no notice of discontinuance was filed by me, who was the only person controlling that case, FC/OSG 139/2015. Anyway, I will show you here now. On the 21st of March 2016, after I had already hired BRL Law Corporation with Mr. Daniel Law, who was an associate, a senior associate, working for me, I shared these video and sound recordings and client documents with my lawyers, who was the BRL Law Corporation at this time in March 21st, 2016, but which Alan Johns had made this Dropbox account, and I had uploaded documents for him. Unfortunately, after I dismissed him, at that time Dropbox did not have the ability to remove people from shared folders, and I used these same folders to share my client documents plus some evidence against Alan Johns for his perjuries and his lies and his attempts to cover up his wrongness, with a letter I'm just about to show you what he wrote to the court when I informed them of this wrongness at the FJC to explain himself. And he joined this Dropbox November, December, January, February, March, 4 months after I dismissed him, in client documents and video and sound recordings, visas Thailand, Singapore, Malaysia. That was a file to show that my son's habitual place of residence was Thailand, not Singapore, despite his Singaporean passport, because for his 5 years of life, 5.5 years of life, he had spent 4 years of them in Thailand. So according to the Hague, that was his habitual residence. You see Alan Johns sharing these share schools. These were all files from the BRL Law Corporation. And Alan Johns joined them, and do you know what he did? Look, here's your folder, which I share with you, the Supreme Court Confidential, the videos. Video and sound recordings. There was a video here with evidence, and he was looking for the screenshot I sent you, which is evidence against him, and he deleted everything here. He deleted any evidence against him. What he didn't know was that in Outlook, in OneDrive, I also had, and in my iCloud, I also had these files triple saved, and on my computer and on separate hard drives, just in case somebody like him did something like this. And so he thought he'd deleted his evidence. He came into my mail 4 months after I dismissed him, signed into my Dropbox shared folder account, and started deleting files, which I was sharing with my legal counsel at BRL Law Corporation, Mr. Daniel Law, who you are welcome to ask about this matter. And he refused to sue Mr. Johns because his company doesn't sue other lawyers, but he did admit to me on the phone that there is something very strange about Mr. Johns' behaviour, but that he doesn't want to, his company doesn't want to take issue with it. But he did admit, after about half an hour trying to prize some kind of statement out of him, with him evading wanting to sue them. But he did admit at the end that yes, I mean, he doesn't want to defame his own colleague. He was being Fifth Amendment style, protecting himself and his company. And so he didn't want to get involved. It was more than his job's worth. But he did admit, he said, Mr. Johns, this is very unorthodox. And his only explanation was maybe he just wanted to look at old files from his old cases for his studies. In which case, why did he delete all of the files here in my video and sound recordings? So, and why was he logging into shared folders after I dismissed him, 4 months after I dismissed him? Anyway, we go now here, that after I said I'm going to sue him for this whole matter, and I reported to the court actually, the Family Justice Courts wrote, we look here, it's January the 5th, right? And this is because on January the 5th or 6th, I believe, if you check yourselves, the case of FC/D 1688/2016, the divorce case, which was being run, there was a case conference. And before that case conference on the 6th, the FJC called Mr. Johns about my report of his wrongdoing, and they sent me this. And Mr. Johns sent me this PDF, which he was forced to by the courts, to show me what he had explained to the courts regarding this GIA case, which has been wrongfully deleted. And here it is. To the Family Justice Courts. And I will attach this to the email when I send you the Dropbox link to this so you can read it all. But what I want to show here is, he said at the mediation session, came up with CRFC mediation on the 6th of October, which I did not attend. Mr. Johns attended and sent me a document of the notice to attend and what was to be discussed, but did not advise me or explain it to me, which you saw in the previous video, which says that 139/2015, FCOSG 139/2015 was also to be, came up for discussion in this. Talked with Mr. Johns, my then lawyer, about it, who never mentioned what was talked about to me or anything. Silence. Here is where secrecy began between my lawyer, whoever was in the CRFC mediation, and I was not informed or advised by my representative. I was only sent a copy of the notice to attend and that he attended, and what was written on the paper to be discussed, but he didn't tell me what was discussed and what was decided. And then so he said that, oh no, now he's talking about the mediation session which I attended with Mr. Johns, whoops, which would be dealt with in FCD 1688/2015. Well, I never said learned judge pointed out that the issues raised in FCG at the said mediation session, the learned judge pointed out that the issues raised in FC OSG 139/2015 would be dealt with in FCD 1688/2015. Whilst in chambers, our Mr. Johns consulted with SLL, that means me, and on his instructions sought leave to withdraw FCOSG 139/2015. That's not true. You look at the transcript of that conference, please, and you will see no words spoken. What happened was that the learned judge said something very vague, which I didn't understand really what was being said, and that my lawyer, Mr. Johns, had his hands and his head on the table, and that I tapped him and looked at him after the judge finished speaking and raised my eyebrows, waiting for him to advise me, and he nodded. And so I nodded, and that was it. And I said further, which will be on the transcript, they said, well, if there are conflictive or not nice things being said in our statements of particulars, we can tone them down, and that we should both bilaterally tone them down. In the end, that turned into the mother didn't have to tone down her statements of particulars. I toned down my statements of particulars, which is what was understood from having been spoken in this session here. That was spoken and that was agreed to. But what is said here was not spoken as far as I was aware. And speaking numbers like FCOSG 139/2015 meant nothing to me at the time. You would have to say your GIA case, your Guardianship of Infants Act case. I wasn't even familiar with the abbreviation GIA. You're speaking to a foreigner and a not lawyer, just a common man. And so I'd like to see a transcript of that, because there is absolutely no evidence that the learned judge pointed out. What the learned judge did point out, though, said that the issues raised in FCOSG 139/2015 not would, that's not what she said. She said could, and would is different. Would require my consent, and it didn't have my consent because I refused. Yeah? I refused that, and in fact, in the transcript of that, you will see me saying, I will not let go of the fact of this is an international parental child abduction, and I will not let go of that, and I said it there, which means I'm not letting go of the GIA case. It's actually in the transcript. And so it was not said would be dealt with, it was said could be dealt with in FCD 168/2015. Here is where I say the judge was hoodwinking me. Why? Because FCOSG 139/2015 is a Guardianship of Infants Act case which has precedents which give a more equal chance to the father of custody. Whereas in FCD 168/2015, we all know around the world that in Singapore, England, and most countries who have a decent kind of legal system, will have the precedent of giving custody to the mother in almost 90% of cases of divorce cases. And so the judge here was telling me they can address my problems and my issues of the Guardianship of Infants Act case, FCOSG 139/2015, equally well in FCD 168/2015, which is not true, because allowing the case to be dealt with in FCD 168/2015 would firstly evade any mention of international parental child abduction, to which I would add that not once during one single conference or court session hearing was the mother advised or informed or what would you say, told off or taught about the seriousity of internationally parentally abducting your child, which is the duty of any judge in a member state of a Hague Convention International Parental Child Abduction Treaty signatory state, according to the guidelines of the Hague member states. And the law of the Hague is that even if it was you were dealing with an international parental child abduction, and because you're not co-signatories with Singapore, I had to file a Guardianship of Infants Act in the stead of a Hague mandate, and the judge tries to talk me into agreeing to delete this, telling me that this divorce case can address the same issues just as fairly. That's not true, because the precedents of a divorce case give custody to the mother in most cases, whereas in cases of Guardianship of Infants Act, the welfare of the child comes first in a much more stronger manner, and the evidence I had to present was really enough to demand return of the child. And so I was hoodwinked here. I feel hoodwinked. I can't say I was hoodwinked because I don't know what the judge's intentions are. But that's what it feels like. And if you've got any other explanation, I'd like to hear it. Because pointing out the issues raised in FCOSG 139/2015 could This word would is wrong. She never said it would be dealt with. She didn't get permission yet from me. I hadn't filed the order to delete it. And then Mr. Johns consulted with SLL and on my instructions sought leave to withdraw FCOSG 139/2015 is not true. I looked at him obliviously wondering what the heck was being meant by the judge, and he nodded, so I nodded. And that is taken as me giving verbal consent to receive permission to withdraw the GIA case. Well, even if I was given verbal consent to withdraw permission, I can change my mind after, and I did. Well, I didn't change my mind because I never decided that in the first place. And I explained to the court that that was a misunderstanding, and I explained to Mr. Johns that that was wrong and that he didn't advise me. And if that was his advice, it was bad advice, and I'll sue him for malpractice. And bad advice to the client, because that is bad advice. Taking $8,000 off me and then telling me, okay, delete it, that would be good. Why? Why would that be good? He couldn't explain why that would be good to remove it. The notice of discontinuance. And I was not directed to file the notice of discontinuance by 17th of October as far as I understood. I didn't understand what was being spoken in the court. And so I claim to have not understood. This is therefore not valid, if that's in the transcript. But you need to look at that transcript and see what was really said, and see what I really said. And you don't forget that at the next session, FCOSG 139/2015 wasn't mentioned, and I was told it was deleted. I made allegations to Mr. Johns saying I'm going to sue him, and he answered me. This is his letter to the court. This is a PDF he sent to the court explaining, trying to get himself out of trouble, yeah, for malpractice. He says here, thereafter, in a series of emails from me, I informed him that he had in fact not withdrawn FCOSG 139/2015, and again made various allegations. Yes, I did make various allegations that he told that he didn't advise me not to delete it, and that the judge had said it, that the FJC had already sent me an email saying it's been deleted in November, and he'd sent me a screenshot saying it was still pending. He mentions the 30th of October 2015 that he wrote to me as follows. We take a serious view of some of the matters. This is where he's talking about dismissing himself. And this is actually just copies of mails. He claims he sent these mails to me. Some of them he did, and some of them are just documents in PDF, claiming they were mails he sent to me, which he never sent. Which this PDF was given to the courts, for the courts to make him disculpable. So he puts for the record, the GIA application was withdrawn on the suggestion of the District Judge Miss Lim Choi Ming. Why should she suggest me to withdraw it? And tell me that the same issues can be fairly addressed in the divorce case. Why should she do that? Why shouldn't she ask the mother to withdraw the divorce case and let the GIA go through first? Because the welfare of the child is of much more importance than the divorce. And a divorce, you need to get divorced before you can address the ancillary matters. And it took 2 years to get the divorce, and any applications or attempts to ask for a regular interim access order were completely ignored. And parental access is one of the paramount important aspects of the welfare of the child, and that wasn't looked at because the Guardianship of Infants Act case was not allowed to run, and this was run as a divorce. And I took nearly 2 years to be able to get to see my son because of that due process. Mr. Johns now claims for the record the GIA application was withdrawn on suggestion of the learned District Judge Miss Lim Choi Ming, which I don't know why she suggested that, because that was to my disadvantage, most obviously and definitely. And the learned judge made this suggestion on the basis that the matters raised in GIA could also be considered in FCD 168/2015. Well, I'll be repeating myself if I said no, they can't, because a divorce case prefers the mother to the father when it comes to custody. So that is a complete deception, hoodwinking, in my opinion. It feels like it. You conferred with our Mr. Johns. No, I didn't. For a brief moment. What this means is I tapped him on the shoulder, told him off because he was sleeping on the table whilst the judge was talking, and he was my representative, and I had to put my hand up and speak in his stead. So I was acting in person even though I was paying him. And it was agreed that the GIA application should be withdrawn. No, it wasn't. I nodded at Mr. Johns nodded at me, so I nodded back at him. That doesn't mean I understood a GIA application I paid $8,000 to file was being agreed to be withdrawn. And it didn't give anybody the authority to withdraw it. It just gave me permission to file, the notice of discontinuance, which had yet to be done, and it was never done by me. And they cannot low anger act in this matter. So they can discharge themselves by my acting person, or not agreeable, and the other options. So I took this, I signed a notice of intention to act in person, which you have, and did not file an application with notice of discontinuance, and waited for a hearing. And in January, I opted for Extreme 1, you see, to file notice of intention of party to act in place. At this point in time, we, Alan Johns, had not filed the notice of discontinuance in my GIA case 139/2015. Subsequent to our discharge, we continued to receive emails from SAL that would point the following exchange of emails. You are a liar and the GIA was removed in contrary to your statement. The reason I told him this was because the FJC had sent me an email telling me it was already removed. And here you can see he says, look, it shows pending. Now he hasn't added the screenshot, the clever lad, because this PDF here is a PDF which he gave to the court when they asked him what the heck is going on with his behaviour after I reported him to them during this case. Yes, he did. Here are the screenshots, So this is the email he sent to me on the 19th of December, after I'd fired him, dismissed him, sorry. I'm not used to your official language, I'm very sorry. I'm trying to be clear. I know I'm digressing, I'm very sorry. It's very hard for you, and I appreciate you if you're watching, if you do take time to peruse this. Saturday the 19th of December 2015, he was already dismissed because, do I remember properly that it was about the 9th of November or something? That, and this is later. Very confusing for me with ADHD. They had not filed the notice of discontinuance. And so he sent me this email saying, look, it shows pending. Because I said to him, dear Mr. Johns, you are a liar and the GIA was removed in contrary to your statement. So why did I tell him it was removed? Why did I believe that? I believed that because the FJC sent me an email, probably in December, not in November, but I don't know, I'm still looking for it, and to tell me that the GIA case had already been deleted, because I sent them an email asking when the hearing was coming, considering I'm acting in person, conducting that case, FC OSG 139/2015. They told me it was deleted, so I wrote this letter to Mr. Johns saying he's a liar, and the GIA has been removed in contrary to his statement that we haven't filed, a notice of discontinuance, and he shows me these screenshots, which maybe I can make bigger here, and we can see it's pending. And I sent you a much clearer one where you can see the date down here on the computer screen, and you can see the pending. Unfortunately, he doesn't click every tab, so we can see every tab. But you've already got that information anyway, And so leave was given and directions were given to file notice of discontinuance. We, however, did not file the NOD. This is Alan John's A partnership. You can see it here in the footer. Yeah, he said, we, however, did not file the NOD. And this is to the register from Alan Johns, all of it. And he suggested I can apply to reinstate, as the same issues are being canvassed in the divorce suit. Well, they're not going to be dealt with fairly. They're going to give custody to the mother in a divorce suit. But in a GAA case, they might not. They might still do it, but they might not. And it suited me better, and it addressed the reality, not the legal fiction, the reality. It wasn't a divorce in custody. It was a case of international parental child abduction from my son's habitual residence in Thailand, leaving the country of a Hague member state to another Hague member state who are not co-signatories without consent or knowledge of the father, of the other lawful guardian. And the Guardianship of Infants Act case can address that, but a divorce suit can't. And it also effectively evades the UN filing a case of international parental child abduction in 2014 from Thailand to Singapore, because it wasn't in the Guardianship of Infants or a Hague mandate. It was dealt with as a divorce suit. And I made that clear during the case conference that I wasn't having that. I wanted the issue of international parental child abduction raised and awareness of it maintained. Your Honour, in the email communication we were attempting to convey to SSL the following points. It's your choice since, my view is this point, it's your choice since you are now having conduct of the matter. Yeah, Mr. Johns told me on the 5th of January 2016, it's my choice since we're having conduct of the matter. Yeah, a few days later that case was deleted without me filing notice of this NOD. Even though it's my choice, since I am now having conduct of the matter. Your Honour, in the email, we are attempting to convey to, he's intended to convey to me the following points. That the issues concerning the child were unnecessary, which is bad advice for the reasons I've already explained, that a divorce case gives preference to the mother for custody. However, if SSLL wishes to pursue the orders, then he could apply to reinstate the same. Curiously, SSL seems to have omitted our email of 19th of December, which clearly states that SLL could apply to reinstate FSOSG. Either I never saw it or I never received it. I can't really give any honest, accurate answer to that. But I am guilty of missing emails sometimes, so I'm open to the possibility of that. We have to be honest when we're looking for truth. But anyway, it's pointless as the same issues could be canvassed. I've already explained the same issues cannot be canvassed in FCD 1688/2015, and I explained that. I explained that in court. For the avoidance of any doubt, Johns would state that any qualification whatsoever, they do not support the various allegations I made by SLL, because they were asked by the court, what's going on with you, what are you up to? And further, that they did not make any statements which may have caused SLL to believe that the allegations made by him in his email of 25th of December were true in any way. As directed, Your Honour will attend the hearing on 6th of January 2015. We will attend. Why should he attend? He's dismissed. But the judge, as directed by Your Honour, we, meaning Mr. Johns, his company, will attend the hearing on 6th of January 2015, which was held by Skype with me in person, and Mr. Johns was not present. And they will answer any questions which the court have to clarify. Now, what happened on the 6th of January 2015, after on the 5th of January, on the 6th of January 2016, after on the 6th of January 2016, Mr. Johns says that I can apply to reinstate the same, and that it is my choice, since I am having conduct of the matter. On the 5th of December, he repeats that in a letter to the court, that he said that. Yeah? And Your Honour here, as directed by Your Honour, so the judge directed Mr. Johns, who didn't work for me, to attend the hearing on the 6th of January. He didn't. What happened was that the judge and Mr. Johns met together half an hour or 15 minutes before the conference hearing began on Skype for FCD 1688-2015, with the mother present, so the plaintiff and her lawyer present in chambers with the judge, and me on Skype in Thailand. And the judge said to me, you can take the transcript, said to me, we have just spoken with Mr. Johns before calling you, and your GIA case is now officially deleted. I complained and said he's not authorised to do so, and neither are you, sir, because I haven't filed notice of discontinuance. Didn't use the file of notice of discontinuance word because I didn't know it. But I said, because I haven't given permission, and you've done it without my knowledge or permission. And he said, well, you can file it again if you like. You're welcome to file another one if you like. And then continued the conference, which went wrong, ending up with me losing my temper and him hanging up on me, which I realise is not a good thing, and it's a shame, because I think it was the first Skype conference, status conference online, which would have been great for international problems of international cases where both people can't be present in the same country at the same time, and I ruined it by losing my temper, and I really regret that. But unfortunately, the wrongness of the act of the judge calling in a lawyer who was not authorised to delete the case when, I quote, Mr. Johns, it is my choice since I am now having conduct of the matter. And on the 6th of December, the judge and Mr. Johns, who had been dismissed a couple of months before, 2 or 3 months before, deleted case FCD 139/2015 without me, the only person who have control of the matter, filing a notice of discontinuance. And that is, I don't know what to say it, and I don't want to, because that would be accusative, and that might make me say something that's not true and defamative. But I think you at the Supreme Courts know what that would be if it is anything, that a judge can call in a lawyer who doesn't work for me when I am conducting a case in person, that hasn't been given a date and hasn't been given, what do you call that again, the notice to discontinuance, NOD, that without the owner of the case signing an NOD is unlawful. And for a judge and a lawyer who is not my representative to do that in cahoots with each other 15 minutes before a case conference to avoid that case from running, obviously, is definitely wrong. If it's unlawful, that's up to you. But I think you have all court records and transcripts, and I think my explanation gives you enough that if you're interested, you can request access to all of that information, which is costly to your resources, and I'm sorry for that, but I think this matter needs clarifying, most definitely, because why the heck should Mr. Johns be called in and forced to open his notebook, open Crimson Logic account and delete a case which he filed for me but which he no longer has control of and is not my representative. And that's all I can give you for now, although I have lots of other emails and things I could show you which will confuse or just expand on the matter to show you more wrongnesses. But I think the heart of the matter has been explained. Very long-winded. Thank you for your time and patience. I hope you don't look to harm me instead of looking into why these people did this thing, because it's wrong. It's definitely wrong. And I thank you for writing to me and asking me to send you this information. I hope you use it for ethical reasons instead of for what those human rights websites say, that the law is used to silence dissidents or critics or people who criticize. I'm not criticizing, I'm showing you something that I think maybe you might criticize because it's your country, it's your justice system, and although I'm a foreigner, this might happen to you as a Singaporean. If you filed a Guardianship of Infants Act case to protect your child and somebody deleted it when you were the only person owning and controlling it in an authorized manner behind your back, I'm sure you would also see it as a human rights offence. So thank you very much, and that's all from me, and I'm very sorry for all the bother. I'm very concerned about my son, but I thought you should know about this. Never mind, I'll sort my own problems out with my son and my joint custody, but you should sort and sweep up your own system, because Mr. Alan Johns is on the Law Society page and his behaviour is not acceptable. And to complain to the Law Society, I have ADHD and PTSD, it's so complex, it's prohibitive and preventative, which protects dishonest lawyers and bad lawyers who don't do their job properly, and misrepresentation all over the place. And I think, well, that's up to you. It's your country, it's your system. If you want a clean one, or you want it to just look clean on the outside, or if you want it to be clean on the inside. I wish you all a good day, and I really hope that you have good hearts and that you look into this. Thank you very much, and have a nice day. Goodbye.